we stand here or there?
Let's get some identification first.
Okay.
Who is Angela Johnson?
I'm Angela Johnson. It's actually my mother's case, and I'm helping her. It's both of us because they wrote the check to me, so we're both
Okay. Ms. Johnson, Angela Johnson, now what is your interest in the case other than helping your mother?
Well, no, I mean, it's both of our cases because they wrote the check to me, the fraudulent check that we're here to deal with the issue on. And so we're both involved. And so the party at all would be Angela Johnson and Beverly Johnson.
Okay.
But they wrote the check originally to her in Medicare, and so it's very important that, you know,
Okay.
she's a part.
Now,
It's her case.
who would actually be arguing or making the presentation to this court this morning?
Well, can we both say something? Would that be all right?
I think, well, now, the total time allotted is 15 minutes, okay? Now, if you want to divide that time between the two of you, you have to let us know in advance how you want to do that,
I think she wants to say something
okay?
as well.
So, who's going to start off?
I think she will.
She will start off.
Uh-huh.
How many minutes will she have?
Well, I guess Mr. Little is here, so the other attorneys had asked for a 5-minute rebuttal. Is that part of the procedure? May I have a 5-minute
You can
rebuttal
have a
to
5-minute
answer?
rebuttal.
Okay. You can approach the podium and then,
Now, she starts off now, and all but 5 minutes of her time will be used by her unless there's some understanding in the beginning that you will be sharing the actual time of presentation.
okay.
You just go ahead and take the time.
Well, you need to say something, I think. You said you wanted to, so.
Well, could I just take 3 minutes?
You can speak, Mom, for a few minutes, and then I'll help you.
Okay. She's going to start off, she's going to initially talk, and you're going to assist her, but the initial part of the time, which I think will be 9 minutes total, y'all going to divide that up, or she's just going to handle it all?
Just speak for a few minutes, and I'll.
Okay, we're going to try to deal with that situation at this point then. Okay. Now, you won't be able to actually stand with her and talk with her at the time.
Okay.
Only one at a time. Okay. Okay. It's my understanding that the initial 9 minutes will be somewhat divided. You will speak for a period of time, and then your daughter will speak for a period of time.
Okay.
For a total of no more than 9 minutes. Is that correct? And then the other 5 minutes will be done on rebuttal. Is that right? Well, that means 10 minutes then, and 5 minutes on rebuttal. Okay? Okay. Yes, ma'am. Just let us know who you are for the record.
Okay, my name is Beverly Johnson, and I'm here today because my husband was killed crossing the road on North Highland in December of 2022. He lived for 60-something days, and he passed away February 23rd, 2023. We have been married almost 50 years. He was very conscientious when he walked. He walked every day because he wanted to keep his legs strong. He had neuropathy in his legs, and he had crossed that street many times. We did not have a vehicle at that time. And he was hit by a car, and nearly every bone in his body was broken. And he there were several things we didn't understand that happened that I still don't understand. Why the man that hit him, there wasn't any kind of a test given to him as to see whether he was drunk or high or impaired in any way. I don't understand that, and I still to this day don't understand. I don't understand if he was speeding. This was a very congested area where there was not, you just didn't need to be driving real fast down North Highland to get to wherever you were going. I'd asked my husband before, why didn't he cross up at the traffic light? But he said that was more dangerous than ever because of the traffic coming in from the sides. But anyway, he passed away, which was devastating to me. He was a microbiologist and a chemist. He was a very responsible person. He took everything in his life very seriously. He was very responsible. And he was just hit. He was hit crossing the road. And it was very, very sad. It put me, of course, in an emotional state, which I still miss him like every single day. But it put me in a financial strait also because he and I were both drawing Social Security. And after he passed away, I was given his Social Security, but I lost my Social Security being a special education teacher with the Jackson-Madison County Schools. So I lost my income, but I was given his income, which was more. He had made more money than I had. It's put a financial strain upon me, and we thought that we were going to get some help from Farmers Bureau. They had told my daughter and I that we were going to get $50,000 and for her to go pick up the check, which at that time I was on a life vest. I had 5 heart attacks. And she went to pick that up, and it was made out to Beverly Johnson, which is me, and to Medicare. And she took that check to the bank across the street, and they would not cash it. So at this point, we have not received anything at all from farmers except grief. They have not been nice. They have not been professional. They have said things that were just lies, really. And I'm just here to try to see if we can't get some justice and something monetarily that would help me in my life at this point.
Okay.
Any questions? Okay.
I hear none.
Okay.
And it's my understanding you would conclude the remaining minutes on the actual presentation.
Yes.
Okay.
There's not very much time, so I want to go, I have some notes on here. Farm Bureau Insurance is the insurance company on the police report and sign at the place of business with street address required to pick up the fraud check that she couldn't cash. They intentionally gave her knowing she couldn't cash it for relief in the death of her husband, and that is still the name of Farm Bureau Insurance in Jackson, Tennessee. They have not performed or tendered a settlement she can cash for her husband's death. They lied about the liability limits. And one of the issues that I think that the opposing counsel has brought up is that we can't bring a direct action suit in the state of Tennessee, but that's actually not so, because this isn't a direct action suit. This is actually a suit that has to do with fraud. So we're blaming them of fraud. And where there is also a case law in Tennessee, and this is important that I add this at this point during the oral arguments because it's not part of the brief, but it's Wendy Leverett et al. Versus Tennessee Farmers Mutual Insurance Company. The number is M2011-00264-COA-R3-CB. It was filed March 4th, 2013. And in it, the ruling was the injured party and the minor's parents jointly filed a suit against the insurance company It was actually Tennessee Farmers, by the way, alleging that the insurance company was liable for breach of contract, bad faith, violation of Tennessee Consumer Protection Act and Unfair Claims Protection Act based upon the denial of coverage. And they were allowed to file and win in a direct action lawsuit, even though it was because the issue was bad faith. And so that's the reason why we're bringing this. It's a breach of contract, it's bad faith. We weren't just going after a lawsuit trying to sue the insurance company with a direct cause action. This is because they wrote us a fraudulent check and they said, this is your payment, and for this, and the whole thing was fraud. Plus, they additionally to that, they said that it was $50,000. It wasn't $50,000. It was $100,000. The claim payouts intentionally says $50,000 to $100,000. They had argued on the other side also that, and this is why Judge Atkins had dismissed it, was because in the state of Tennessee, there are cases where people have they have liability insurance. All insurance companies are not the same. So some have liability insurance claims, and in those liability insurance claims, they say you have to pay a certain amount to the Medicare or to the medical bills, and it comes from the bodily damages. But in this particular case, Dylan Thomas paid quite a bit of money and for his insurance. It was supposedly, Farm Bureau is supposedly a good company with regards to insurance. And so we have a copy on the original pleading, not only of a copy of the check that they wrote that was fraudulent, we couldn't cash, and they intentionally told us that was going to help my mom, but also where it says coverage, limits of liability, it says bodily injury, $50,000 to $100,000. The amount of premium he had to pay on that was $234. Then it has property damage. Medical payments is a totally different injury, $5,018 a month premium. Then uninsured motorist, BI, uninsured motorist PD, comprehensive, that's $1,000. Then that was $156 per month that he had to pay for that. That fixed his car, I suppose. And then collision, $1,589, and then auto rental expense that was $50, and that was the premium on that was $28. So, and then clearly also they told us that it was only $50,000, and it wasn't $50,000. He passed away, and we gave them a copy of the death certificate, and so that was $100,000. So that's like three things that's fraudulent that they've done to us. I mean, so I don't see how that we would not be eligible for a fraud case and for damages for that. I have 51 seconds. They lied about the liability limits, gave the evidence at time of issuance of check on the last day of filing a wrongful death case or any action against Mr. Dylan Clark, the driver of the vehicle that struck my father, Mr. David Johnson. It's fraud to issue a check knowing the intended party cannot cash. The law states if appellate court finds in our favor, they must pay 3 times the contractual amount they should have paid. That law is stated in the brief separately to us as victim's family and to Medicare POMCO for medical bills. They could not have legally denied a payment to us with bodily damages death listed as policy coverage based upon the facts of the accident. And so far, Mr. David F. Johnson's family or Medicare POMCO have received not 1 penny from the insured driver or his insurance company via Farm Bureau Insurance or their umbrella company, Tennessee Farmers Insurance. And I would like to note that if they do this, I noticed in the law, if they do the 3 times what it's actually supposed to be, and that you guys find that that is what you want to do, 100,000 of that, 300,000 would go towards the state in order to educate people about how to avoid insurance fraud. And that's really important because Dylan Thomas purchased that policy, and I mean, you want to know what you're buying.
Your time is up, but you
Okay.
do have rebuttal time, though.
Thank
Okay.
you.
Yes, sir.
Good morning, Your Honors. I'm John Little from the Madison County Bar. It's my privilege to be here on behalf of Tennessee Farmers Mutual Insurance Company. There are no suitable words in a situation like this, especially in this formal situation. However, personally and professionally, I once again offer my condolences to the Johnson family. Obviously, this is a deeply disturbing and sad situation for the entire family. But simply put, Tennessee Farmers has done all that it can do in this case, and that is by paying all that it can pay. To the extent that the appellants are arguing that there is any type of premature dismissal of this action, I would just point out that this was a Rule 12.06 motion, and nothing was considered by Judge Atkins outside the scope of the pleadings. To the extent that this is a wrongful death claim, Tennessee is not a direct action state, and the lawsuit should have been filed against Dylan Clark, who was the alleged tortfeasor. Today, I hear more explanation of the theory of the appellants in this case, and it seems like today what they're saying is that this is basically a case of an allegation of fraud or bad faith on the part of Tennessee Farmers. And I'll just address each of their arguments separately. First of all, there's no question that Tennessee Farmers tendered a check in the amount of $50,000 to Beverly Johnson. Tennessee Farmers was statutorily obligated to protect Medicare's interest in this case, which was quite substantial, given the fact that Mr. Johnson stayed in the hospital for a long period of time. Tennessee Farmers was very upfront with the Johnson family. As early as October 24th of 2023, Mr. Deal for Tennessee Farmers explained the Medicare issue to the Johnson family. This is included in emails which the Johnsons have attached to their pleadings, and the court can clearly see that Mr. Deal was reaching out to Medicare as of October 24th, 2023. This sort of dovetails into the next issue, which is in reference to the amount of the coverage limits. Ms. Johnson is arguing that the coverage limits of Mr. Thomas would allow for a payment by Tennessee Farmers from the amount between $50,000 and $100,000. However, that's simply incorrect. This is a split limits policy which provides for $50,000 per person and $100,000 per accident in the event that more than one person is injured. Since there was only one person that was injured, the first half of the split limits is available for payment, and that's what they've paid. To the extent that there is an allegation that this is fraud because the check can't be cashed, I would point out that this is a situation in which Tennessee Farmers didn't have a choice but to protect the interest of Medicare without the possibility of facing severe penalties themselves under the Medicare Secondary Payer Act. This also protected Ms. Johnson because she could also have some exposure under the Medicare Secondary Payer Act if that lien is not protected. I would point out that the check is there. If it goes stale, it can be replaced. That's nothing unusual in any type of financial situation in which there's a check that's not cashed in a timely way. It can be replaced. What needs to happen is Medicare needs to be brought into this, and Medicare needs to either release their lien or reduce their lien. And when the case was first filed, and when I first became involved in this, I sent Ms. Johnson a suggestion that we could avoid all of this by simply resolving the issue directly with Medicare, and suggested to her that she should hire counsel or that she herself should negotiate with Medicare by accessing the cms.gov site in which this issue could be resolved. Ms. Johnson is obviously very sophisticated in her ability to navigate certain things as she has gotten here to this point. And so this is a situation in which this case could just simply be resolved by resolving the lien. There is, there was at least some allegations from Ms. Johnson earlier that Tennessee Farmers delayed resolving this case until the very last minute. I would point out that the record shows that Ms. Johnson was represented at a point in time. Tennessee Farmers couldn't deal with her directly until it was informed that she no longer had counsel. Tennessee Farmers provided Ms. Johnson with a copy of the declarations page of Mr. Thomas in order to show her what the coverage limits were. And just simply put, there's just nothing else Tennessee Farmers could have done other than pay the $50,000 the way that it did.
Thank you, sir. And for the rebuttal? You have
Okay.
5 minutes to rebut what he said, I believe.
Okay. It is untrue that, that they did not haggle with me for an entire year. I called and they would not answer my phone calls. And we, at one point, tried to get an attorney involved, and then we decided not to do that. And then we just asked the insurance company for the damages, and then we went back and forth for about several months. I mean, it was months and months. Then they waited until the very last minute to issue the check. And then when I went in to get the check, he got the signature from me. I didn't think in a million years anybody would do that. And he got the signature from me, and he handed me that page and handed me that check. And I looked at it and I said, "Now it's made out to her in Medicare. Is that okay?" And he was like, "You have till 5 o'clock to file." And he just stormed off. And then there were these two guys over there, and they were like, "Did he get the signature?" Like letting me know that if I signed something, then I messed up, or and I was like, "What?" And so I called the courthouse and asked them what I should do, and she said I could file out of time with cause if I explained to them what had happened. And so then it went to Kyle Atkins, and then now we're here in court today. So I just want to reiterate Tennessee Code 53102, especially a claim for payment or benefit pursuant to any insurance policy, and also anything that diverts, misappropriates, converts, or embezzles funds of an insurer, an insured claimant or applicant for insurance in connection with an insurance transaction, the conduct of business activities by an insurer or insurance professional. And then there's a lowercase b on this particular law that I put into this document. It shall be unlawful for any person to commit or to attempt to commit or aid, assist, abet, or solicit another to commit or to conspire to commit a fraudulent insurance act. So I don't really know if there's any such thing as a fraudulent insurance act other than that's like the most extreme fraudulent insurance act I think anyone could experience. As far as him saying it's split claims, that's the first I've heard of that. And actually Judge Atkins was talking about, he talked about the division of if there's multiple parties involved. And I think he deals with a lot of insurance companies. But my concern is not only for us and what we went through, but also for everybody in Tennessee. That insurance company is evil, and they need to be reprimanded, and there needs to be punitive damages. And we've requested in, all of the different punitive damages that we want in writing. And then it's very important that that people are not misinformed about that. I mean, if someone purchases a policy and they think, hey, this is going to cover me if something happens, or which I'm not arguing for Dylan Thomas, but I mean, the guy did pay for the insurance. So I don't understand why it is so difficult for people to get claims awarded. They don't have any problem fixing his car, but they have a problem paying out. And my dad's dead. There might have been other factors included in that, but there's also, he would not have ever been in the hospital if he had not been hit by a car. And Dylan Thomas was the insured, and that is the insurance company. And that's the insurance company's lawyer that we're dealing with today. And that's because they promised to make good in a term limit. There's no, my dad's worth billions of dollars, not $50,000, but that's the term limit that they said it was. And then that's not even true. It's $100,000 term limit. But, I mean, that, again, that's, and that is, again, another issue why we're here on appeal, because they denied discovery, and it's inside of the court record that Judge Atkins, I asked for discovery, he denied the discovery, I asked for the complete contract. The opposing counsel argued that that they had a complete, full contract that was more detailed, that would tell if it's split, or if it has to do with bodily damages versus death. And we're not privy to that information. We don't have that information. The thing was dismissed, and that's why we're here, because it shouldn't have been dismissed, and we should have justice, and it's not right. And so the only other thing I know to bring up besides the law that's already been brought up is I also wanted to state that, let me see, I'll probably, okay, we are also asking, Medicare did not receive their money, and it's also Medicare and/or Palmco. He had private insurance. So it would be $300,000 to us for that, and also a $10,000 penalty, which is in the law as well. No less than $100 to $10,000 for a penalty. Then you're always allowed to award punitive against the company. But then
Johnson, I think your time is
15,000,
expired.
I'm out of time.
Your time is.
15,000, okay, I'm not so worried for Medicare.
Well, thank you for your presentations, and we will review this case thoroughly, and we will make a decision and make a ruling on this case within a reasonable period of time, and you will be notified of our ruling, both sides, okay? Thank you very much. Madam Clerk, will you please recess court until 1:30 this afternoon?
All rise.